Welcome to our webinar on 10 tips for avoiding Employment Tribunal claims in 2019. These aren't the only tips for avoiding Employment Tribunal claims, but they are 10 tips that we've selected specifically for 2019 based on our experience and my experience of handling tribunal claims and trying to avoid them in 2019 so far. To introduce myself, my name is Owen John. I'm a partner and an employment lawyer here at Darwin Gray, and hopefully you'll find this short webinar useful. So some background information for you. Back on the 26th of July 2017, that was quite a significant day in employment law in the UK, because that's the day that employment tribunal fees were abolished. So previously you would have to pay £250 for issuing, for example, a standard unfair dismissal claim, and £950 before you could take that claim to a final hearing. However, with the scrapping of fees, we saw a significant increase in the number of claims brought, and the latest stats out from the Tribunal Service show those figures of claims being brought increasing again. There has been talk of reintroduction of fees to a more modest level than they were previously. However, our understanding is that it's not a priority for the government at this stage, but it's something that they will be looking at. So what does the scrapping of fees and the increase in claims mean for employers? Well, from our experience, things that we've seen, trends that we've seen this year, is that generally speaking, employees are more likely to take the risk. There's no economic cost to pursuing tribunal claims now, so they will take a punt where they feel they want to. More employees are acting unrepresented, so without a solicitor or a trade union representative on their behalf, and that does present challenges, particularly in defending claims, and it does generally make tribunal proceedings more time-consuming. We're also finding cases taking longer to be heard. So with the Tribunal Service being incredibly busy, it's not unheard of to see claims take a year from issue to final hearing. I had a final hearing only last week that was a claim that was issued 12 months prior. So it is taking an incredibly long time for claims to reach the tribunal hearings. Our tip number one is on conditional offers, because we're finding that lots of disputes are arising right at the start of the employment relationship. So we consider that it's important that you make it very clear what the conditions of an offer of employment are right at the start so that it can be withdrawn easily. Now, if you make, as an employer, an unconditional offer, then you are always obliged to provide a notice period to that individual in order to withdraw that offer. Whereas if you make an offer of employment conditional on certain things and those conditions aren't met, you are able to withdraw that offer without being tied down to a notice period, which sometimes can be quite lengthy. Some of the conditions that we see attached to offers of employment are satisfactory DBS checks, confirmation of right to work in the UK, certain medical issues, sort of fitness to work in certain lines of work where that fitness to work can be justified, and that's important to note. And finally, clean references. Our second tip relates to the employment contract. So by law, an employer must provide a written contract of employment to an employee within the first 8 weeks of employment. But it's one thing having a written contract in place, and it's another, from an employer's perspective, having one in place that protects you as the employer and also works for you. So some important clauses that should be contained in a written employment contract. So we've got notice down there. So often employers will fail to specify that there's a shorter notice period in a probationary period, and that can prove problematic as employers are tied down to lengthy notice periods right at the start of the employment, so very early on in the probationary period. So we would advise that a shorter notice period is included specifically for the probationary period. Pile-on clauses, so pay in lieu of notice clauses, these are really useful because they allow you to, as an employer, to end the employment relationship sooner and make a payment in lieu of notice rather than having to put an individual on garden leave or having an employee work their notice period. Deductions from wages is often a cause for disputes because unless you get the agreement of an individual, on the whole, you need an express clause in that individual's employment contract in order to be able to deduct sums from that individual's wages. So, for example, if you've overpaid them or the individual has taken too many holidays, you need a specific clause in the employment contract allowing you to deduct from their wages. We always advise not to make procedures or some of your policies contractual. So, for example, your disciplinary and grievance procedures, those contained in your staff handbook. I'll come on to that a little bit later, but we always advise to make those non-contractual so that they can be changed more easily without any suggestion of a breach of contract. And finally, be careful of contractual bonuses and commissions. This comes up all the time, and we often see disputes around the whole issue of what is a contractual bonus commission scheme and therefore is set in stone, and what is non-contractual and can be easily changed from time to time. And often there is a blurring of the lines between what is discretionary and what is contractual. We always say that it's incredibly important to be specific in the contract on whether a bonus or a commission scheme is contractual or not. Our third tip is to publish your policy. So it's one thing having a staff handbook which contains all the required policies and procedures, but it's another thing entirely having a staff handbook that is accessible and a live document. So not sat on a shelf gathering dust, but that is out there and accessible and is available for individuals to view and to query. So some of our tips on this are that you should keep records when those policies are provided to staff so that you've got a paper trail showing that staff have had access to a particular policy or to the staff handbook as a whole. We would also stress the importance of specifying that policies and procedures in your staff handbook are non-contractual. Now, the reason for that, as I mentioned earlier, is that it's much easier then for you to change those policies from time to time without the allegation or the suggestion that you're breaching anybody's contract. We advise that people review them regularly. For example, lots of data protection policies needed a complete redraft last year when the GDPR and the Data Protection Act 2018 was introduced. Those policies, some of them I saw, hadn't had much attention since the introduction of the Data Protection Act in 1998. So lots of policies should be reviewed on a fairly frequent basis. And finally, you should train your staff on them. Now, it's very nice, of course, to offer training to staff, but it's also incredibly useful. And I've had, for example, lots of employers who have been in a sticky spot where they've been defending discrimination claims, for example, and being able to point to the fact that they have trained managers and employees on equal opportunities and harassment and bullying and discrimination issues has been invaluable, actually, in assembling a defence to that discrimination claim. You know, as an employer, you're able to say, well, at least we have taken all reasonable steps to train employees in order to avoid discrimination in the workplace. Tip number 4 is practice what you preach. So whenever you are confronted with, for example, say a disciplinary process or a grievance process, it's always good practice to refer to your particular policy dealing with that area and use it as a guide. So often we find that individuals will try and pick holes in any flaws, any procedural flaws in, let's take disciplinary processes for an example. And it's a particularly easy win for an individual if they say, well, you know, as an employee, you don't even know your own policy. How can your disciplinary process have any legitimacy when procedurally you don't even follow what you have written down in your disciplinary procedure? So that's an incredibly important first tip. And secondly, exception. So when you might need to depart from particular policies. So taking disciplinary action, for example, we always advise that it's important that policies do specify when, for example, you're able to deal informally with disciplinary matters. So our fifth tip is to avoid discrimination, because all employees and prospective employees are protected against discrimination. And unlike with unfair dismissal claims, for example, where employees need 2 years service in order to present those particular claims, that's not the case with discrimination claims. Indeed, discrimination can become an issue from the moment a job advert is sent out and from the moment that an individual applies for a job. Now, there are 9 what's called protected characteristics under the Equality Act, so 9 areas in which an employer should not discriminate against an individual. Those are age, sex, religion or belief, pregnancy or maternity, marriage or civil partnership, gender reassignment, sexual orientation, and disability. Now, turning to that last one, because of course we could do a whole webinar on discrimination as a topic in itself, but turning to disability discrimination, one particular area that arises quite a lot in disputes that we find is the issue of reasonable adjustments, because there is a positive obligation on an employer to make reasonable adjustments to the role of an employee who is disabled, deemed disabled under the Equality Act, and that obligation kicks in not only where the employer is aware of that disability, but where that employer ought reasonably to be aware of that disability. Now, that's a really difficult area of law, and it will often mean that a suspicion of a disability is enough for the obligation to make reasonable adjustments to kick into play. One final point that's worth making is that even though it's not included in the Equality Act and it's sometimes overlooked, there is an obligation on employers not to discriminate against part-time workers. Now, the reason it's often overlooked is that the obligation not to treat part-time workers less favourably is contained in a separate set of regulations, separate from the Equality Act. Tip number 6 is don't neglect your paperwork. So it's fine acting fairly and doing everything very nicely and very fairly, but it's another thing entirely being able to prove that. So this is where paper trails become incredibly important. So a few tips that we've got. So point number 1 is to take detailed notes of meetings and to ask the employee to sign those notes to prove that they've agreed with them. Now, that's not a legal requirement at all, but it's incredibly good practice and will avoid lots of disputes further down the line. Our second tip is to keep copies of correspondence. Now, this is where the paper trail is key, because it's one thing acting fairly and doing things by the book, but it's another thing entirely being able to prove that. And if you play devil's advocate, you should consider that if an issue becomes a dispute, an employment judge who has never seen anything to do with this issue before and knows nothing about the parties will be looking at a paper trail and will glean things from that. So be conscious of that. And finally, remember your data protection obligations. There's particular sensitivity around this issue with lots of disputes arising from it. It's important that you have a clear set of documents in place in relation to data protection that will include privacy notices and data protection policies. And number 7 is remember the reason, this being the reason for dismissal. So there are 5 potentially fair reasons for which an employer can dismiss an employee. They are conduct, capability, redundancy, illegality, and the final one is some other substantial reason. Now, it's important that you're incredibly mindful from the outset, if you are looking to dismiss, what your reason is, and that you hone in on that particular reason. Because if you don't, a tribunal will genuinely see through that. The band of reasonable responses is the test that is applied by a tribunal when determining whether an employer has fairly dismissed an individual. Now, different to a criminal court, for example, where the burden of proof is beyond reasonable doubt, the burden of proof in the Employment Tribunal, or the hurdle, if you like, is set much lower than that. The bar is set at what a reasonable employer might have done. Now, the reason for dismissal is relevant to whether the ACAS code applies, because the ACAS code technically only applies to disciplinary and grievance procedures. So, generally speaking, it will apply to conduct type dismissals. But it's also important to be mindful that the ACAS code has got incredibly good guidance for following a good, reasonable, fair process, whatever the reason for dismissal. The last point was, when does SOSR apply? So some of the substantial reason is often referred to as the catch-all reason, when an employer can't slot a potential dismissal into any of the other 4 reasons for dismissal. More often than not, when we use SOSR on behalf of our clients, we use it where there is third-party pressure. So where a third party whose relationship with the employer is incredibly important puts huge pressure on the employer to dismiss an employee. That's often where that particular reason for dismissal comes into play. Our 8th tip is to follow a fair process. Now, having a fair reason, as we've discussed previously, is important, but it's not enough. Investigation, impartiality, and reasonableness are crucial to affecting a fair process and therefore a fair dismissal. So the ACAS Code of Practice contains lots of useful guidance for following a fair process. It's important to bear that in mind. And lots of your policies and procedures, for example, your disciplinary procedure, will take the ACAS Code into account and hopefully will provide better protection and better requirements than the ACAS Code. Now, when to use suspension? There's been an awful lot of case law on the issue of suspension, and the general feeling now is that suspension really should be a last resort. And even though suspension is not in itself a disciplinary sanction, it's been found by case law not to be a neutral act either. So it really should only be used for specific reasons, where there is a good, legitimate reason for using it. For example, it would prejudice the process, or would damage the business, or would negatively affect others if the individual remained performing his or her duties during the period of potential suspension. And you should also explain that reason and set that out in detail in writing to the individual who's being suspended. Now, independent decision makers is very important, and by that we mean a separate decision maker for an investigation stage and a disciplinary hearing and an appeal hearing. We've got postponing hearings down there because this is a significant cause of disputes that we find, where individuals will try and get hearings postponed. Our advice is always to be very reasonable and be very fair in relation to any requests for postponing hearings. And it's always important to foresee that if this goes pear-shaped and it ends up in an employment tribunal, again, a judge who has never seen anything to do with this matter before will consider it. And therefore, as an employer, you want to protect yourself by appearing as reasonable and fair as possible. Our 9th tip is to consider speaking off the record. Now, this will often mean having a protected conversation, or it will sometimes mean speaking off the record or without prejudice to an employee. Now, the difference between both is that the without prejudice protection is there for when there is an existing dispute between the parties, whereas a protected conversation is there when there isn't an existing dispute. So, a protected conversation is almost there to assist an employer who wants to take an employee into a room and have an off-the-record chat where there has been no cause for dispute up until that point. It's important that the employee is made aware that it's off the record, and it would be good practice, whilst not to minute anything, it would be good practice to have another person there with you whilst the off-the-record conversation is happening, in order to back up, if you need to one day, the fact that it was a protected conversation or a without prejudice conversation. We always advise that it's important to be very specific about an offer and not to allow any unrealistic expectations to materialise, or not to be vague about anything. And finally, it's important to give an employee a deadline for when they should return to you with their decision on any offer of settlement that you put to them. Our final tip is to be sensible about settlement. Now, a significant proportion of employment tribunal claims do settle before they reach the employment tribunal hearing. And the reason for that is the cost of litigation, and also the cost reputationally, and also the time and management that is taken up by defending tribunal claims. And that's why we always explain to people that there is a cost in litigating on principle. It's fine making an example of defending something robustly, but you should be very conscious of the cost and the economic impact and the management time impact of that. ACAS have now got their early conciliation process, so every individual who wants to present an employment tribunal claim must go through the early pre-claim conciliation process. What that means is that there is a defined window for considering settlement, which can prove very useful. And on to the next point, when is best to make an offer of settlement? I mean, this will vary greatly from case to case. It really will. I mean, I have claims that have settled at the door of the tribunal hearing, and I've had others that have settled before the claim has even got off the ground. It really will depend on the circumstances and how best to tactically play things from the employer's perspective. In terms of getting the paperwork right, COT3 agreements will generally be a very easy and inexpensive way of effecting a settlement where there is an existing claim, and ACAS are involved, whereas a settlement agreement is generally used before that point, before a claim is brought. So those are our 10 tips for avoiding employment tribunal claims in 2019. I hope you found them useful, and thank you for listening.